Alrighty. So we have a decision out of New Mexico that a district court judge was forced to rule the 7-day waiting period in Ortega versus Grisham unconstitutional. We're going to get into it, what it means for you, because the victory isn't as clear cut because of um, what some of the stuff that the judge said. All right, so let's back up a little bit. This district court judge ruled originally that the 7-day waiting period for the purchase of firearms in New Mexico was constitutional. It went up to the 10th Circuit, and the 10th Circuit said, not so fast. This is unconstitutional. They remanded the case back down to the district court judge and ordered him to rule for the plaintiffs in this. So that's what we're going to be talking about today, exactly what was said, and we're going to get into it here. So let's jump into it. Okay, so the 10th Circuit says that the waiting period to purchase a firearm is unconstitutional. This judge issued a ruling. He was not happy about this because he said that he still believes that it is constitutional. But the 10th Circuit ordered him to issue a ruling for the plaintiffs, so he did. But there's a catch to it. And the catch is that he severely limited his judgment, if I'm reading this right. So the 10th Circuit said that it fails Bruen. The federal district court is bound by the 10th Circuit decision. But instead of enjoining the law, which I think he should, it looks like what he said could be interpreted in two ways, and he didn't make it too clear, which is probably intentional. The first thing he did, he said that he enjoins the law against Ortega and Scott. Those are the plaintiffs. If you read it on face, you can take it as that the injunction only applies to the two named people, Ortega and Scott. So that's one way to read it. Another way to read it is that it's going to protect all New Mexicans, which would be good. Now, what's going to be interesting is how the Attorney General and the state interpret the injunction today, whether it's only going to cover Ortega or Scott or every New Mexican. I believe it should cover every New Mexican, because if a gun law is unconstitutional for two people, it should be unconstitutional for everyone. So we're going to have to see what happens. But if it's just in the 10th Circuit and it does apply to everyone, it's only going to apply inside the 10th Circuit. So that means any law for waiting periods outside the 10th Circuit, they can still uphold the waiting period. Let's say, for example, someone challenges a California law that has a waiting period. The 9th Circuit can disagree with the 10th Circuit because the 9th Circuit is a different circuit, and because we have a court case called Trump versus Casa, there can't be a universal nationwide injunction made by a circuit court. That is the purview of the Supreme Court. But let's say the 9th Circuit does take a challenge to a waiting period, and they rule that the waiting period is a-okay and it's constitutional. What that will cause is a circuit split. A circuit split is the fastest way to get a writ of certiorari granted. A writ of certiorari is a petition to the Supreme Court to hear the case. Now, there's about a 1% chance that the Supreme Court will take up a writ of certiorari, but if there's a circuit split, those odds greatly increase. Shout out to C&T Designs out there. Thank you for being a channel member. I appreciate it, bud. So, either way, this is the first step of getting this to the Supreme Court. The battle's not over, and there might be other lawsuits depending on how the AG of New Mexico, particularly, interprets the injunction. They might have to go back to the 10th Circuit. It wouldn't be a new lawsuit, but they would go back to the 10th Circuit and say, hey, they're limiting it too much. So this could be a re-won movement, a moment, or this could be a we won, but just not on a greater scale than what we should. Either way, waiting period is unconstitutional. A right delayed is a right denied. And I think in the long run, the Supreme Court is going to have to weigh in on that because there's a lot of places that have waiting periods that are not in the 10th Circuit, that are in less gun-friendly circuits, such as the Ninth. And with those rulings coming out, that's going to cause a circuit split, which will almost guarantee that the Supreme Court is going to have to review it because you cannot have two sets of laws in two different parts of the country. Like it can't be constitutional under the United States Constitution in one circuit, and it cannot be unconstitutional in another circuit. So we're going to have to see exactly what comes out of this. I don't think that the AG or the state of New Mexico or any of the other states in the 10th are going to be quick in actually coming out with guidance. And that is because they want to delay the implementation of the killing of the waiting period law as much as possible. Another thing that the 10th Circuit decision did do, and the other cases which are dealing with waiting periods in other circuits, the lawyers for the plaintiffs can file what's called a motion of supplemental authority, which saying, hey, look at this is what the 10th thinks. We think you should take guidance from the 10th. Now, the other circuits don't have to take that, but it does give a little bit of strength to that. But until we hear what the AG of like New Mexico says, we're going to have to find out. All right, guys, that is it. Short video. Just wanted to put that out there. But yeah, that's it. So tons of ways to support me down below. And like, comment, share, do all that other good stuff. And I will see you guys later.